Welcome to the deep dive. Today, we're tackling a really interesting question where, good intentions meet the law head on.
That's right.
When someone promises a big donation to a charity, let's say $15,000, is that just a nice thought? Or is it actually a legally binding promise?
It's a classic tension. You've got contract law, which usually demands a two-way street in exchange for what we call consideration.
Right, a quid pro quo.
Exactly. But a charitable pledge, that looks like a one-way street, a gift. Courts have, well, struggled for ages to figure out how and when to make these promises stick, because charities obviously rely on them.
Okay, so our mission in this deep dive is to chart that struggle, right? We'll look at how the thinking evolved.
Precisely. We'll start with the older, sometimes kind of strained, ideas about finding consideration where maybe there wasn't any. Then we'll move to promissory estoppel, a common fallback.
And see why that didn't always work either.
Right. And that leads us to the modern rule, the one the court landed on in a key case, Salsbury v. Northwestern Bell Telephone Co. Following this path should really clarify how we got to the current standard. #tag the search for a binding rule.
Okay, let's start back at the beginning then. Contracts need consideration, that exchange. So why did courts try so hard to, well, invent theories to enforce charitable pledges? It seems like forcing it.
Well, because enforcing these pledges felt important for society. Charities do vital work, but the strict legal rules didn't easily fit.
So they needed a legal justification, even if it was a bit thin.
Yeah, they had to find some kind of legal detriment for the charity or a benefit for the donor, even if it wasn't really an exchange in the typical sense. They were trying to make philanthropy fit the contract mold.
Can you give an example of one of these fictional theories?
Yeah.
And why did it eventually fall out of favor?
Sure. The big one was the mutual promises of other subscribers idea. You see this in older cases. The argument was basically that my promise to donate is the consideration for your promise to donate, and vice versa. We all promise together.
So the deal isn't between the donor and the charity, it's between the donors themselves, kind of horizontal.
Exactly. The charity is just the lucky recipient, the beneficiary. But, critics pointed out this just isn't how it works in reality.
Right. I don't promise money because someone else did.
Precisely. Your motive might be belief in the cause, maybe tax reasons, maybe public recognition. You make the promise to the charity, not really in exchange for Joe Smith's promise down the street. Plus, pledges often come in separately, not in one big group negotiation.
So the theory just didn't match the facts on the ground.
It really didn't. It felt artificial.
Okay, so if that consideration fiction wasn't working, courts often look towards another doctrine, promissory estoppel. What's the basic rule there? What's the key thing you absolutely have to prove?
Right. Promissory estoppel is about fairness when someone relies on a promise. The general rule is that a promise can be enforced if, 1, the person making the promise should have reasonably expected the other person to act or not act because of it.
Okay, expectation.
2, the other person did actually rely on the promise, often by spending money or changing their plans. That's the crucial detrimental reliance part.
They have to have done something concrete based on the promise.
Yes. And 3, injustice can only be avoided by enforcing the promise. But the absolute linchpin is that detrimental reliance. The charity has to show they were worse off because they trusted the promise.
Okay, reliance is key. Now let's connect this to the Salsbury case. The college chairman, John Salsbury, was trying to get the phone company's $15,000. But here's the crucial fact. He admitted he had not even seen the letter promising the money until shortly before trial.
And that is, well, that's a huge problem for a traditional promissory estoppel claim.
Why specifically?
Because reliance requires a connection. The promise has to cause the action. If Salsbury, the guy in charge, didn't even know about that specific letter, how could the college possibly have relied on that letter when making decisions?
It couldn't have. The cause and effect is broken.
Exactly. There's no inducement based on that particular promise.
So under this traditional promissory estoppel rule, Rule 2, Northwestern Bell probably gets off the hook. No reliance, no enforcement.
That's most likely correct. The court noted they probably could not be bound on the pledge under that standard. And this highlighted a policy issue.
Which was?
If courts strictly required detrimental reliance for every charitable pledge, a lot of important donations wouldn't be enforceable, simply because the charity hadn't spent the money yet or couldn't prove direct reliance on that specific pledge. This seemed counterproductive.
So the courts needed a different approach, especially for charities.
Yes, they started looking for a standard that better reflected the public importance of philanthropy.
And this is where the Salisbury court made a significant move. What specific rule did they adopt to get around this reliance problem, explicitly acknowledging why charities are different?
They adopted a modern rule found in the Restatement of Contracts, second, which basically carves out a special exception for charitable subscriptions.
A special exception. How does it differ fundamentally from promissory estoppel?
It's a major shift. The rule essentially states that a charitable subscription is binding, without proof that the promise induced action or forbearance.
Wow. So no reliance needed.
No reliance needed. Basically, if you make a clear, definite promise to a charity, public policy says that promise should be honored, period. The charity doesn't have to jump through the hoop of proving they spent money because of it.
Okay, that is a fundamental shift. Let's apply this new rule directly to the Salsbury case, using that structured FIRAC approach. First things first. What are the key legally important facts?
All right, the core facts are: Northwestern Bell's local manager wrote a formal letter to Charles City College. In the letter, he promised a $15,000 donation. Critically, this wasn't just his idea. The letter stated it was approved by his superior, the district manager.
Giving it official backing.
Exactly. And the letter specified the payment plan: 3 equal payments, once a year, starting in 1968. So quite specific.
Got it. And given those facts, what was the central legal issue the court had to decide?
The main question was, is Northwestern Bell legally required to pay that $15,000, even though everyone agreed there wasn't traditional consideration, and the college couldn't prove it had detrimentally relied on that specific letter?
Okay, so what rule of law did the court use to answer that? State the rule and break down its testable parts, its elements.
The court adopted the rule from the Restatement Second, Section 90, subsection 2. This rule specifically says charitable subscriptions are binding without needing consideration or detrimental reliance.
So it just wipes those requirements away for charity cases.
Correct. Which means the court's actual test boiled down to something much simpler. Was the promise made in the letter a valid charitable subscription? And the key element they focused on for that was whether the promise was unequivocal.
Unequivocal, meaning clear, definite, unambiguous.
Exactly. That became the main hurdle. Was this a firm commitment?
All right, now for the court's elemental analysis. Let's go step by step. They only had one main element to check here: unequivocal. How did the court figure out if the promise met that standard?
Okay, so the mini RSV for unequivocal. The sub-issue is whether the letter showed clear commitment. The sub-rule is that general statements of support aren't enough. It needs specifics.
Right.
So the court looked closely at the letter's analysis. Did it just say, "We support the college"? No, it named the exact amount, $15,000. It laid out the payment schedule, 3 specific equal annual payments. And crucially, it mentioned the official approval from the district manager. This wasn't just a casual note. It had internal corporate sign-off.
So applying those facts.
Applying those facts, the court found the promise was absolutely specific and formal. It wasn't vague. It was a clear, definite commitment. Therefore, the element of being unequivocal was met. They distinguished it from cases involving just vague pledges of general support.
Makes sense. So having analyzed that single key element under the new rule, what was the court's final conclusion?
The Iowa Supreme Court upheld the trial court's decision. They concluded that Northwestern Bell was legally bound to pay the $15,000
And the reasoning.
because the pledge documented in that letter was unequivocal. Under the Restatement Second rule they adopted, that was enough. Public policy supported enforcing such clear philanthropic commitments, even without reliance or consideration. #, visceral hypotheticals.
Okay, this distinction between the rules is critical. Let's use a hypothetical to really drive home the difference between needing reliance, Rule 2, promissory estoppel, and not needing it, Rule 3, the Salsbury approach. This should help listeners really grasp it.
Good idea. Contrast helps cement it.
Imagine a wealthy pharma exec publicly promises $1 million to the local children's hospital. The plan is to build a new, super specialized, hyper-sterile wing for treating kids with, extremely rare and dangerous parasitic infections.
Okay, big promise, important cause.
The hospital board is thrilled, naturally. They immediately go out and spend, say, $50 on a nice framed photo of the architect's first concept sketch for the wing. But that's it. They don't hire anyone, don't break ground, nothing else significant yet.
Just the photo.
Just the photo. Now, suddenly, the pharma exec changes their mind and revokes the $1 million pledge before paying a cent. How does the hospital's legal case look under Rule 2 versus Rule 3?
Okay, this shows the difference perfectly. It's stark.
Let's start with Rule 2, traditional promissory estoppel. What happens there?
Under traditional promissory estoppel, The hospital's only provable reliance is that $50 photo frame.
Right.
Now, they'd argue they relied, but the court looks at that $50 expenditure versus a $1 million promise.
Hmm.
It's alliterative.
And, well, it's tiny.
Insignificant, legally speaking.
Disproportionate.
Hugely. A court would likely say that $50 reliance is too minimal to justify enforcing the entire $1 million pledge. Maybe the hospital gets their $50 back. But more likely, the court says the reliance wasn't substantial enough to meet the avoiding injustice part of the test.
So the hospital probably loses the $1 million for the wing.
Almost certainly, under that traditional rule, the $50 just isn't enough to hang $1 million enforcement on.
Okay. Now, flip it. How does the exact same scenario play out under the modern Salsbury rule, Rule 3, adopted from Restatement Second?
Complete change. Under the Salsbury rule, the $50 photo is, well, it's irrelevant to enforcing the main promise.
A hospital doesn't even need to bring it up.
Nope. The only question is, was the pharma executive's $1 million promise unequivocal? Was it specific about the amount? Was the purpose clear? The new wing? Was it made formally, indicating a serious commitment?
Let's assume it was a clear letter, specific amount, named purpose.
Then, if it meets that unequivocal test, the promise is binding. Full
Hold
stop.
up.
The fact that the hospital hadn't relied yet by spending significant money makes absolutely no difference under this rule.
Wow.
The hospital gets the $1 million. The public policy favoring enforcement of clear charitable pledges overrides the lack of reliance.
That really highlights the shift. The law basically said, for charity, a clear promise is enough. ## exam framework synthesis.
Exactly. So to wrap this all up and give you a practical tool, let's synthesize this into a clear step-by-step checklist. Think of this as your diagnostic framework for analyzing charitable subscription issues.
Perfect. Let's hear the steps.
Okay, step 1. Always start with the basics. Is it a traditional contract? Look for actual consideration. Did the charity promise something specific in return for the donation, like naming rights agreed upon in advance?
And check for that old mutual promises fiction.
Right. Quickly consider and likely dismiss the mutual promises of other subscribers' theory unless the facts are really unusual. If you find real consideration, great. It's a straightforward contract, probably rare though.
Okay, so if there's no traditional contract, what's step 2?
Step 2. Check traditional promissory estoppel. This is where reliance is key. Ask, did the charity actually rely on this specific promise? Did they change their position, spend money, hire staff because of it? And was that reliance reasonable?
And remember the Salsbury issue, if they didn't know about the promise, they couldn't have relied.
Precisely. If there's no demonstrable reliance, or if it's insignificant like the $50 photo for the $1 rent pledge, then a traditional promissory estoppel claim likely fails.
Got it. So if both traditional contract and traditional PE fail, what's the final step?
Step 3. The modern public policy rule, Salsbury Restatement Second. First, does the jurisdiction you're in follow this modern rule, Restatement Second, Section 96N? Many do, but it's crucial to check.
Assuming it does.
If it does, then the analysis simplifies dramatically. You ignore consideration, you ignore reliance. The only question is, was the charitable subscription unequivocal? Was the promise clear, definite, specific about the amount and intention?
And
If yes, the promise is binding. That's it. Unequivocal promise to charity equals enforceable pledge in these jurisdictions.
that framework makes the progression really clear. From forcing consideration to requiring reliance to finally just demanding clarity in the promise itself for charities.
It really shows the law evolving to meet a perceived social need. And the Salsbury court itself pointed out a very practical reason for this final step.
What was that?
They worried about the old rules creating a flood of needless litigation. Think about executors of estates. They'd be hesitant to pay out on a pledge without a court order if the law was fuzzy.
Right, they need certainty.
Exactly. By making clear, unequivocal charitable pledges binding on their own terms, the modern rule provides that certainty. It helps charities operate and fundraise without constantly facing potential court battles over promised funds.
So that $15,000 promise, if clear and written, holds up not just because it's nice, but because the law evolved to say clarity is enough for these important social commitments. A fascinating journey through legal adaptation.
It really is. It shows how legal doctrines aren't static. They can bend towards public policy over time.
A great point to end on. Thanks for walking us through that complex evolution.